Greetings and salutations. Welcome back to another instructional series from the Legal Beagle podcast. We're working on getting Brett and Brandon back to do the real teaching, but until then, they're pretty busy with a lot of legal stuff going on, if you know what I mean. But in the meantime, I thought it might be helpful to go over some causes of action, help write complaints and things of this nature, and go over the elements required to do this. So we're going to go through these real quick. If this is not what y'all want to see, let me know. If y'all want to see something different, please let me know what y'all are looking to see, and we'll try to get it in there in the meantime until we get back to our regularly scheduled program with Brandon, and hopefully Brett will do a series on all the ticket stuff and citations and things of that nature. But in the meantime, our first cause of action we're going to go over is the criminal conspiracy and the legal standards needed for that. And the burden of proof in conspiracy cases are: 1, a criminal conspiracy must be established by proof beyond a reasonable doubt. So I think that pretty much states what is pretty much the prosecution's burden. Has to be established beyond a reasonable doubt. And number 2, to prove a prima facie case of conspiracy, the state bears the burden of proving beyond a reasonable doubt that the conspirators recognize that they entered into a common plan, knowingly intended to further the plan's common purpose. So whether that's to violate your rights or disenfranchise you in any way, or take away some privileges without due process, if multiple agencies and multiple people conspire together to do that, this is what would be needed in the cause. So basically, when you write your complaint, there's you got a facts section, and that facts section should contain all the evidence needed with exhibits to prove these things to put in your cause of action. So when you get down past the facts section, you start in your first cause of action and second cause of action, third cause of action. That's what these are here. So this would be the conspiracy, what you needed to do. And the factors establishing this conspiracy would be the factors of relation between the parties. So that's the nexus between the state and the private party that you're suing, or if you're just suing a private party, you can't have a conspiracy suing one corporation. A corporation can't conspire together within itself. It would have to have an external factor. So in, for instance, Brandon's Oshner case, or Toro case, the nexus would be that the government coerced, or they colluded with the private entity hospital to fire or have retribution against his daughter in order to make this stick, right? So it can't just be a conspiracy within a corporation itself. A corporation can't conspire against anything. They're built by definition to conspire to create money. But moving on, proving the agreement. It is the state's burden to prove the agreement or agreements underlying a conspiracy prosecution made by the defendant and at least one other person. Right, what we just went over. Under an indictment charging that only 2 named persons conspired, the identity of those 2 persons becomes an essential element of the offense. And the state has the burden of proving beyond a reasonable doubt that the defendant conspired with the person named in the indictment. Now, I realize this is talking about the state's prosecution proving a conspiracy, but these are the same burden of elements whether you're bringing the cause of action in a civil case or they're doing it in a criminal case. So all of these things have to be met. You need all the facts to support this to be able to put this cause of action in your complaint. Multiple conspiracies. Where the state charges a defendant with multiple conspiracies, the state has the burden of proving a separate agreement for each conspiracy. So you're going to have to prove. So in the Toro case, we're talking about the agreement we'd be talking about would be John Heaton and the CEO of Toro, I forget his name, but they have signed an agreement with the CDC saying that they're not going to force or coerce anyone to take these experimental drugs that EUA authorized without giving them, proper notice of the downside and full education on what they wanted, what's required, full education of the consequences of taking it. So they have to tell you the known factors, benefits, and deterrents of the EUA product in order to force you to do it. And they can't force you to do it under any circumstances. They agreed to allow everyone to make their own decision, but that's not what we've seen so far. So second part would be further, the government must prove beyond a reasonable doubt that the defendant had knowledge of the essential object of the conspiracy and voluntarily participated to achieve the criminal objective. So in the Toro case, they've signed the agreement with the CDC saying it must be a choice made by each person, and the obligation of Toro is to give each person they're trying to coerce all the facts relevant, good, the upside, the downside, etc., and they have to let them make their own choice. That's not what happened here, yet they had an agreement to do so. So that would be the nexus that puts them all together, that makes it a conspiracy, right? The time of the conspiracy and affirmative defense. The government satisfies its burden in a conspiracy prosecution of proving the time of the conspiracy when it proves that the conspiracy continued past the statute of limitations period. And number two, abandonment or withdrawal is generally considered an affirmative defense, and the defendant has the burden of proof on the issue. Allocating to a defendant the burden of proving withdrawal from a conspiracy does not violate the due process clause. Okay, so this will be this is the next cause of action we're going to get into, the constitutional right violation using excessive force. So pulled over on the side of the road, cop jerks you out of the car using excessive force. These are the elements that you need to put in your facts section in order to prove that it was a constitutional right violation with excessive force. So to allege the violation of a constitutional right based on excessive force, a plaintiff must show, one, an injury. So you have to show that they injured you in some way. Now that could be, taking away your bodily autonomy without due process. If you didn't commit any crimes, that they don't have any articulable state of crime, suspicion of crime, then that would be an injury. They could actually physically injure you, of course. Causing bruises, bumps, things of this nature would be an injury, or there's many other types of injury in the law that you could associate with that situation. So you have to establish an injury first. Number two, which resulted directly or only from the use of force that was clearly exerted excessive to the need. So you're going to have to prove to them that the injury was directly related to the excessive force. So this is really kind of leaning now towards if you got injured, if they broke a bone, if they caused a bruise or nerve damage, or they tased you, or something of this nature. And the force used was objectively unreasonable. And so I think a good example of this would be Beth over there in South Carolina. They jerked her out of her car, threw her up on the hood of the car, arrested her, put handcuffs on her. She still has, feeling damage in her thumbs from the cuffs being too tight. And the fact that they jerked a 100-pound woman out of the car when they stopped her for a seatbelt violation, just because their arrogant attitude, their puffed up chest, just because she tried to exert some rights. And this cop thought that, well, I know the law, you don't know the law. And, the arrogance is what made it objectively unreasonable for a seatbelt violation. And this is out of the Fifth Circuit, Hale versus the city of Biloxi, Mississippi. So the next cause of action we're going to go over today is the deprivation of civil rights. So the legal standards required for that. And those are, number one, the defendant's acts must have deprived someone of a right secured or protected by the Constitution or laws of the United States. So you know the Bill of Rights well as I do, or you should. And so if they've deprived you of those rights without reasonable articulation of suspicion, then that's a violation. The second element you need to put in your fact section is the defendant's illegal acts must have been committed under the color of law. So they must have, not had that reasonable suspicion, or they didn't watch you commit an actual crime, and yet they're exercising their authority over your bodily autonomy. And so that would be under the color of law. They're stepping outside of their scope of their office in order to conduct this search or whatever they happen to be doing to you at this time. Number 3, the defendant must have acted willfully. So they must have willfully wanted to do this. But in the cases we're talking about, that's clearly, especially if it's you and one other officer, then clearly he's going to act willfully. If he was ordered to do something, or if he was responding to something that you did, that may have threatened him, then that may cause you to have a little issue here in the cause of action. Number 4, the person deprived of his or her right must have been present in one of the areas detailed in the statute. So you need to look in your state statutes and make sure that you fit in all that. But basically, you have to be present to be injured normally. I guess there's some instances that it could happen without that, but in this particular instance that we're talking about, you have to be the one injured. You have to bring the case. Physical abuse or violence is not a necessary element of offense under the statute. So, doesn't have to be physical abuse. Maybe even mental or negligence. Now we're going to go into, so this ties in with the excessive force we were just talking about, but this is the Fourth Amendment violations, essential elements. Number 1, the defendant was acting under the color of law. So we talked about that. He has to step outside of his scope of his office in order to offend your rights. And that's not following due process, for instance. Things of this nature. The defendant deprived the victim of the right to be free of unreasonable seizures, including the right to be free from unlawful arrest and to not be subjected to excessive force. And so this is talking about when the officer doesn't follow due process and he just arrests your liberty without an articulable suspicion of a crime, or without witnessing the crime, or without a signed document or complaint from a citizen, under penalty and perjury, saying, yeah, this person committed a crime and he needs to be arrested. So this would be stepping outside, in the color of law, and stepping outside the scope of office to deprive the victim of the right to be free and unreasonable. Number 3, the defendant acted willfully, that is, with a bad purpose, intending to deprive the victim of the right. So knowingly, even especially after many of you, explain your rights to the officer, and he ignores it and continues down the path, or ignores the fact that you need to go see a magistrate before he locks you straight in the jail. If you've requested the magistrate and your state statute says you need to go to the magistrate before jail, the cop is not the jailer. He should not have the key to the jail. The magistrate should have the key to the jail. The magistrate should order you to prison or not, based on the probable cause and the of what happened and the testimony there in court. So if you've asked to go to the magistrate, they don't take you there, bring you straight to jail. Here we go. He's acted willfully outside of his scope of office, under the color of law. And number 4, the offense resulted in bodily injury to the victim or included the use, attempted use, or threatened use of dangerous weapons. So this is going back to the excessive force. And so if they've, obviously if they've got a gun in their hip and they've ordered you something and they tell you that you will be arrested if you do not, or you will be subdued if you do not comply, then that is enough to offend this statute here, or qualify for these elements here. So it's the next thing we're going to go into is criminal trespass. So the legal standards for criminal trespass. The burden of proof for criminal trespass. Number 1, when property is open to the public at the time of an so this goes back to all the COVID stuff, right? So when the property is open to the public at the time of an alleged criminal trespass, the state has the burden of proving. So you walk in, you're not wearing a mask, they call you, they ask you to leave, and you refuse to leave, and the officer shows up and hands you a criminal trespass violation and kicks you out of the store. Well, these are the elements that are required to do this. So under number 1A, a lawful order excluding the defendant from the premises issued. So a lawful order would have to be given. So I guess that could be by the officer. And the order was communicated to the defendant by a person with authority to make the order. Now, the officer does not have that authority under this particular situation. The owner of the property would have to, or the leasee of the property would have to do that. A manager is not qualified to testify or sign a complaint to remove you from the property if you haven't done anything illegal. So if you've entered the building legally and you're conducting legal acts within that building, then there's no authority unless the property owner shows up or the signed lease owner shows up, which in the case of Walmart is never going to happen, right? And C, the defendant defied the order. So it's really hard to see where they write that criminal trespass here for the things they've done. And moving on to number 2, the state may not satisfy its burden of proof by relying on a presumption that the public official authorized to maintain order on the premises discharged his or her responsibility in the particular instance in a lawful manner. And so they're going to have proof that they did this under legal manner, which is a signed complaint, by the owner of the property. Number 3, the state is not required to prove that the defendant defied an order to leave communicated by the owner or authorized person in order to establish a violation of criminal trespass statute, requiring only that the notice to not enter be given by actual communication to the defendant. So unlawful entry on public property. Where public property is involved, before a person may be convicted of unlawful entry, the prosecution also is required to prove an additional specific factor establishing the defendant's lack of a legal right to remain. Number 2, the purpose of this requirement is to protect all citizens against capricious and arbitrary enforcement of the unlawful entry statutes by public officials, so that an individual's otherwise lawful presence on public property is not conditioned upon the mere whim of a public official, which is what is occurring now. The officer signs the complaint, you have to show up, and it's really not a lawful action of due process that they're conducting. And moving on, number 3, the additional specific factors which must be established by the state in prosecuting a person for unlawful entry on public property may consist of posting regulations, signs, or fences and barricades regulating the public's use of government property. So this is talking about government property. So moving on to our last cause of action is conversion. It's taking of an automobile taking property without due process is what this is about. Elements of conversion. To prove conversion, a plaintiff must show 1, a right to the property. So you must have a deed or ownership. Usually possession is 9/10 of the law in this particular case. Number 2, an absolute and unconditional right to the immediate possession of the property. So that, like I said, title, deed, possession, these type of things. 3, a demand for possession. 4, that the defendant wrongfully and without authorization assume control, dominion, or ownership of the property. And this is case reference Russell Dean Incorporated versus Meyer. And so, the elements of coercion, whether they tow your car, and you haven't given permission and they haven't given you due process, that would be an example of conversion. So let us know what you think about the causes of action here that we went over. Tell me what other ones you want to see, or if you want to see something different about writing complaints, please let us know. But in the meantime, y'all have a wonderful day.